So, city officials cannot just arbitrarily deny applications, but they also cannot necessarily arbitrarily approve applications. And this Idaho Supreme Court ruling, which is around September of 2023, shows what can happen if elected officials um, approve something uh, perceived to be arbitrary, and then somebody sues them on the city level or some association and gets it overturned. So some part of it, like regarding fire portions of it, regarding the fire coverage, and somebody brings it up as an issue and it's not really addressed within the public documents or the public hearing or as part of the discussion, and then it ends up needing to, like, the approval ends up getting overturned and sent back to be reviewed again. So everyone paid legal fees for this, and for what end? So I'm going to read through this article, and it gives a lot more detail on Boise Dev. So Idaho Supreme Court sides against Boise in prominence lawsuit, but doesn't move to stop project. A long-running lawsuit over a proposed large northwest Boise development is over, with neither side claiming total victory or defeat. On Thursday, the Idaho Supreme Court issued a ruling in a lawsuit from the Northwest Neighborhood Association against the city of Boise, seeking to overturn the Boise City Council's 2019 approval of the 226-unit Prominence Subdivision project. The lawsuit contended the proposal from CBH Homes and Trilogy Development for a more than 30-acre parcel of North Bogart Lane was illegally approved due to concerns with the burden on fire service in the area and traffic. 10 months after oral arguments, the Idaho Supreme Court issued a unanimous ruling partially overturning the approval of the Prominence Subdivision and ordering it to be remanded back to the city of Boise. Therefore, the Boise City Council will have to draft a new reason statement laying out a more robust factual case for why the subdivision should be approved. At that point, the city council can, but isn't required to, take more public testimony. However, despite the ruling that the city's factual statement for why it approved the project was lacking, the procedural error is not enough to overturn the possibility of the project being built, because it didn't impact the Northwest Neighborhood Association's rights. Since then, every single seat on the Boise City Council turned over, and Mayor Lauren McLean runs the city instead of Mayor Dave Beater. Plus, the city has also since committed to building a new fire station this year at the corner of Bogart Lane and State Street to serve the residents in the area. This ruling strengthens a precedent that Idaho's visionary Local Land Use Planning Act does not merely outline a series of meaningless steps required to adhere to the law. NWNA President Richard told Boise Dev, I'm just skipping the pronunciation here, the court made clear that conclusory post hoc rationalizations of city council decisions cannot substitute for meaningful deliberation on the evidence. This ruling, along with the construction of a long-promised fire station, is a victory not only for Northwest Boise but all residents of Idaho. Neither side was awarded attorney fees. This ruling partially overturned a district court ruling on the case 2 years ago. ISC, show your work. When local governments approve new development projects like Prominence, they have to provide a reasoned statement laying out the facts and legal argument for why they made their decision. A major part of ISC's ruling said the city of Boise didn't provide enough reasoning for why it moved to approve the project and overturn the Planning and Zoning Commission's recommendation to deny it. Specifically, the court found the reasoned statement did not address any of the fire safety issues or traffic concerns by NWNA in any meaningful fashion. The City Council must explain in a reasoned decision whether the project complies with the level of fire service set forth in the comprehensive plan and whether the project is in the best interest of the public's general welfare. And the City Council must also set forth the facts upon which it relies to make those determinations. The opinion said the closest the city's statement comes to addressing the fire service issue is when it noted public agencies say the project will not place an undue burden on the transportation system or other infrastructure in the neighborhood, but there are no factual conclusions to support it. The opinion also said it would not require the city to say how the council's decision was different than planning and zoning commissions to deny it, because that decision also lacked supporting factual arguments. Subdivision will not be overturned. There were two aspects to the prominence application, a rezone and a planned unit development. A rezone asked the Boise City Council to increase the maximum amount of homes allowed on a property or the use of a property to change. A planned unit development develops the layout of a subdivision, like where roads and individual lots will go. Part of NWNA's arguments against the approval of prominence was that the city didn't follow procedure when it approved the planned unit development because it allowed the developer to return with a revised plan instead of sticking with only considering what the Planning and Zoning Commission deliberated on. But ISC pointed out that Idaho code allows developments to be legally approved even if they violate procedure, so long these errors don't hurt the substantial rights of the group filing suit against the project. In this case, NWNA contends the council's alleged errors result in the prejudice to its members' use and enjoyment of their properties, opinion said. We agree with the developer that the assertion is nothing more than a generalized grievance associated with any development of the 38 acres and is not linked specifically to the proposed project and is certainly not linked to the approval of the PUD application. Okay, so I poorly summarized it at the beginning, but basically it was like a procedural error. And that's why, it's interesting because, I just, had us looking at all of the Ada County subdivisions, and I believe even with the city of Kuna. And I don't know, maybe because of this, cities have kind of changed their procedure, but they're always very careful. They have this huge checklist of all the agencies that they check with to make sure that they're okay with it. So if they just went to the fire department specifically, or the whatever the fire agency is for that area, and got the comment saying, okay, yeah, it'll be fine. We'll still be able to manage services. Or I think one of the ways they do it is they send out a request to them for feedback, and then sometimes they don't respond. So that's just assumed, okay, well, I guess you're okay with it, because they have a window to apply. Yeah, and then you have the Planning and Zoning Commission, right? Normally, especially with the city of Kuna, the Planning and Zoning Commission, and even with Ada County, they really don't have any sort of. They can only recommend. They say it's like a dress rehearsal for the final approval, which is usually with the city council or the Ada County commissioners. That's where the rubber hits the road. That's where the final approval goes. But still, the Planning and Zoning Commission, if they deny it or recommend denial, and then the Ada County or the actual decision makers, decide to approve it, they need to have that sort of discussion, and you see those like in the videos or the transcripts or in the minutes, specifically saying, okay, these are kind of the reasons why the Planning and Zoning may have denied it, but upon reviewing of the facts, they might have missed these kinds of facts. We believe it should be approved, and the main issue is that it can't just be arbitrary, and explain it to a degree that is sufficient that if judges review it, they have to say, okay, there seems to be a reason that is explained. So it seems to be more of a procedural thing. The planned unit development or the subdivision can probably still go on, and it may already be in there. So it's a lot of. So this is that code I was talking about in the previous video. Maybe not that specific code, but just kind of this general understanding that everything is subject to judicial review. So those hearings, even the Planning and Zoning Commission, you want to cover everything. If some neighbor brings up anything, you want to discuss that issue, right? And cover it and remediate it if there is a possible way to do it. Get it all covered, because if you don't, it opens the doors for somebody to challenge it in court, and then you risk the judge overturning it and then having it back to be reviewed again. All right, well, that's about it. Have a good one. Bye-bye.